Senior Counsel Ahmed Nasir, Senior Umbati present, all colleagues, Chair of Lands Acquisition Tribunal, and all our members present. So it's a pleasure to have us today. I know we have started a bit late. I think the rains must have caused a bit of delay in terms of arrival. But for the members who cannot join, I hope the live stream is clear for everyone. So before we start into the conversation, I'd want to introduce Senior Counsel. He says he denies that this is his bio, but this is the bio that we received. So it starts with publisher, news columnist, staff advocate, husband, businessman, father, clothes horse. You need to tell us what clothes horse is. Hellraiser. Then there's Arsenal FC. This last one, I'm not getting it. The Grand Mullah. Feel free to wedge any of these hats on Ahmed Nasir's head. It will fit. He began his schooling at Mandera Primary School before proceeding to Nairobi School, where he earned points to join the university. He went on and joined the University of Nairobi, graduating in 1990. He then proceeded to Cornell University, the Cornell Ivy League University, where he undertook a master's in law. He was also admitted to the bar in 1993 and went on to establish a law firm in the name of Ahmed Nasir and Abdi Kadir and Company Advocates, which has now been established for 3 decades. Grand Mullah, as so many of you know him, has also served being the first Judicial Service Commissioner post-2010 Constitution, and through that role we have seen transformative reform in the judiciary. He's also known during his tenure as the president, or rather that time the chair of lack of jurisprudential depth. Is this a problem of the judiciary, or advocates have contributed to it? You speak aggressively about lack of jurisprudential depth. Is this a problem of the judiciary, or advocates have contributed to it? I'll go into a bit of controversy where you're known as the Hellraiser. What was your main controversy under Justice Quach, and where do you draw the line between robust criticism and limits of decorum? And what is your assessment of the quality of litigation and judgments of the Supreme Court? We'll just have those to start the conversation. We welcome comments, questions from members to keep this conversation burning. And Zach will be moderating as senior. I just said we start with a few questions to allow senior to kick off.
Yes, thank you very much, Madam President. I'm happy to be here today. I don't get invited to many places nowadays. Most people nowadays think I'm not politically correct, but I think that comes with the territory. First, I'm glad that you have invited me to, kick off this discussion on the role of a lawyer in the judicial or the justice ecosystem. And this ecosystem basically has, 3 main players who maintain a delicate equilibrium, both historically and the present. And there's a one victim of that 3 players. The 3 players are the executive. The executive has a lot of interest in how the judiciary works or how it should not work and what kind of justice it should deliver. The second player, is the judiciary. This is a principal player in terms of, the juridic quality of, the justice system in the country, defined by, historically, incompetence was a very important role. Lack of independence was another, but corruption has always been the common denominator, both historical and the present. And the third player, in my view, is LSK and lawyers. We are the third, important player in this sector. And historically, when I was both a student and during my formative stage of practice, including the time I was chairman of Law Society, LSK was a very powerful institution. I remember, and I'm not bragging, when I give a press statement during my time, I think about 15 times it will be the headline of all the three papers that the Law Society has said this. I mean, we were very important institutions. I'm not hitting at the current or the Law Society, but I think in terms of how the public or the politician value us, we have gone down a little bit. People don't fear us anymore. I mean, sometimes they notice when we go to court on public law litigation, but most often than not, I think they can afford to ignore us. So these three players, I mean, it is a tough war. The justice sector is a tough war between these three players, the judiciary, the lawyers, and the executive. But they have one common victim, who is, the citizen, the client. I mean, more often than not, he's a victim. Sometimes his case is compromised because of poor advocacy. Sometimes the government can interfere with his case. Sometimes judges take bribe and his rights is compromised. So those three are, I think, the main players in this. And as we discuss this topic, we will be seeing more various facets of the same. If I go to the first question, you speak aggressively. Is it because of lack of jurisprudential depth or in the judiciary, or do advocates play a role? My notoriety in the profession, or why I became chairman of Law Society, is attributed to, okay, I had a lot of students who voted for me, my students, but one factor is, Kigoro called me one time and said, there's a conference of the Law Society at this hotel in Utali College. So he said, can you present a paper? I said, yes, I will present a paper. So that paper, it was titled, what was it? It was something about why we need to fire all the judges of the High Court and the Court of Appeal and reconstitute both courts afresh. And I'm glad, the discussion I kicked in that played a huge role in the radical study of 2003 and eventually became part of the constitutional reform we had when we said we vet the judges. Because Kenyans were really fed up. But everybody thought there's this young man who's sitting at the university, he's a madman. How can he talk something like this? Then there's a phrase I used in that paper. When George Bush, the first George Bush was president during his first term, I mean, he never had a second term. Normally, the Economist magazine normally has 6 top editors. So at the end of the year, they have like a conference of just those editors, and they discuss world politics. And there are people with a lot of brains, so they talk a lot of sense. So when they were discussing the tenure of George Bush, they said George Bush, they said that I quote, they said he's so shallow that he has given the word shallow a new depth. End of quote. So George Bush said that was the first time in his political career that he called an editor to complain about how he was described. So when I was presenting a paper, I specifically referred to one judge, which I will not name because he's deceased. And I said he's so shallow that he gives the word shallow a new depth. And that story was a big story at the back. It was a Friday, so it was carried by the Daily Nation at the back page, and they used that phrase. Then the next Monday, I appeared in court, the commercial court, which was during its formative stage. I appeared before Justice Tom Mbulutu. Then he saw me, he said, Ahmed, what was that you said over the weekend? I said, as you have read it in the papers. Then he said, how can you say such a thing and then come to the court? I told him, those are my views. Then he said, you have to apologize. I said, I will not apologize. I told him, if you have a contrary opinion, you can always present it to Kenyans, let them hear. So that's how it started. But in terms of, I don't think I speak aggressively. I just speak truth to judges. And I've been consistent. I mean, it's not something I pretend. It's something that comes because of the situation. Last time when I appeared before the Supreme Court, I was doing this case for Iranian, the terrorists, the two guys who were convicted. And I came to that case, just I did it. I wasn't involved in the case in the trial court or in the high court, but I got involved in the court of appeal. And I appeared before Justice Minoti, Kihara Kryuki, and someone else. And I always tell guys, the judgment of the court was, the quality of that judgment was sort of like an indictment on my advocacy, because I didn't argue the case as well as the judge wrote the judgment. So it was on confession. So the court said, the confession was not reliable, so they quashed the decision of the High Court and they set them free. When the Court of Appeal set free, drama started because the government got very involved, especially the intelligence. So they refused to release them. Then they made an application to the Court of Appeal to appeal to the Supreme Court as, a matter of national importance. So I told the court, the issue that the Court of Appeal decided was on confession. The law of confession is settled. You don't have to go to the Supreme Court for that. The court agreed and said they refused them leave, and they said that unless you hold these guys lawfully, you must release them. So this case shows judicial independence at its worst, because I know the government spoke to Justice Maraga and members of the court, and then the government came and said that they want to appeal. So Maraga said that confession is such an important issue. Actually, he didn't say confession, to be fair to him. He turned the issue now into one of terrorism. He said that's a matter of national importance. So they gave the government leave. Then the scandal, which people don't appreciate in this country, is they made a ruling to say that so I told them, okay, these guys should be released. The embassy can keep them as we wait for the appeal. But since the judgment of the Court of Appeal has been delivered, there is nothing like staying it in a criminal case. You have to release the accused person. No, so this is the beef I have with the Supreme Court and the Maraga Court especially, because they made two judges, to their credit, dissented. No, they dissented actually in the judgment, but in the interlocutory application for leave, the court said that when the government is appealing a criminal acquittal, whether from a magistrate court or the High Court or the Court of Appeal, the accused persons should continue serving his sentence. Yes. They say that. So when you are, in other words, because it's so ridiculous, nobody follows it. Even the DPP doesn't follow. They are saying, for example, that when the chief magistrate acquits you, you should serve a sentence. Yes. Or when the High Court acquits or quashes the decision of the magistrate court and the government is appealing, you should continue serving the sentence that was quashed. Anyway, they quashed, they allowed, then we went to the main appeal now. So the main appeal was on, as I said, confession. It was obvious to the court, so I made a lot of noise. I expressed my views. I told them, that the government has spoken to you. That's why you are doing all this. And which was the case, by the way. So I'm told when they were writing the judgment, the court was split. Justice Ibrahim and Smoking dissented. The others, I think, Maraga, Lenola, and Joki agreed with the government. But they had an issue. They wanted to find me contempt because of Justice Professor Ojwang was also there. So they wanted to find me in contempt, but they have not cited me. So they couldn't do it. I'm told they wanted to find me like 500,000. So they had an issue. So they said, what do we do? They wrote 2 rulings. One judgment about the case, and I think a 15-page about me now. Yeah? And that ruling, you know, every time I'm on one side of the case and a lawyer wants to carry favor with the court, they bring it. As recently as 3 months ago, someone was citing in the Supreme Court and he said, you know, the court, look at the judgment of the court, Ahmed says this about you every time. So, I mean, I'm not really aggressive, but I think if we keep quiet about, you know, the injustices you see, if you keep quiet about the corruption you see, it dehumanizes you actually. I mean, your value as a human being, if you can't speak the truth, especially when you are a lawyer, I mean, I think it's an indictment on you as an advocate. I have never shied from a judge. I think there's a time I appeared before Justice Visram, when he was a duty judge in the Down High Court. He was a duty judge, and of course he was. I've told him he's a gatekeeper. And it was in the papers that I told him a gatekeeper, and he was a gatekeeper. So, but if we tell the judges what they are, if we tell them, you know, they are gatekeepers, or they are corrupt, or they are this, they're human beings. They will take it, and they will even probably change or probably moderate their conduct. But if we just keep quiet about it, you know, like nothing happens, why should we change? You know, a judge takes bribe in a case and nobody talks about it. I mean, he will even be invited on some workshops to give certain issues, to talk about the virtue of a good judge or issues like that. My controversy with Justice Squad was during that time when I gave that lecture, there was a public debate. I treated a public debate on how to reform the judiciary because nobody has ever talked about the judiciary. So, Nation read some commentaries where I watched, you know, rights, then they invited me to write and reply back. So there was, you know, that back and forth. But don't get me wrong, but I can tolerate a corrupt judge that does not pontificate when he goes to a church or mosque and talks about the virtue of a good judge. But I can't tolerate a corrupt judge who pontificates about the virtue of a good judge when he goes to a church or a mosque. Yes. I don't like that hypocrisy of a corrupt judge. That's my woe with judges who are corrupt but pontificate. But if you are corrupt and you are under the radar, you are under the radar, I may not have. I mean, I know you are corrupt, but I will not fight you. But if you want to lecture the country about the virtues of a good judge, for God's sake, don't be corrupt. So that's one of the issues I have with the judges. I mean, in terms of jurisprudence, you know, to be fair, in the 80s and 90s when the judiciary was Africanized, I mean, appointment of judges, especially during Moi's time, was on politics, you know. I mean, there was a tribal balance they were keeping. They used to look at who is from which community, who will support, you know, those kind of things. And the quality of judges was very deplorable, you know. I mean, good judges here and there, but there was a lot of mediocrity in the bench. Now with the new constitution and, you know, with the JAC normally interviewing guys, there is a modicum, there's quite some improvement on the quality of judges we have. I mean, when I was there, and I speak only when I was there, we used to employ people on merit, complete merit. Okay, there are guys who will stop here and there because of their record in their bar or in the bench or something. But 90% of the guys we used to employ was on merit. We didn't care whether he come. Sometimes, okay, I mean, sometimes we could say, for example, if there are certain communities that are not represented in the court, we could make a special dispensation. I mean, if there is no, for example, a Maasai in the High Court, or a Samburu, or a Somali, or a Borana, or a Rendile, or even our super, yes, or even white Europeans or Asians, we could make those special dispensation. But it doesn't mean they were not qualified, only that maybe we were taking 10, and then a Maasai finds himself in number 11. We will take him, and we will leave the person who is number 10. So there's a lot of competence has improved a lot. I mean, they're good judges now. We have, great intellectuals in the court. But that has been eroded by corruption. Corruption, I mean, if you look at the corruption in the courts in the 80s, in the 80s, 90s, the 2000, 2010, and now, I've seen it all, but I have never seen corruption on this scale. It's like it was, it's like, there was a price control in the 80s, 90s, and now it's liberalized. Completely. And I tell guys, corruption in the judiciary arises only under two conditions. When you have a law society that does not talk about it, that's a big factor. If the law society talks about corruption, if you threaten judges, everybody in this country listens a lot to the law society. So if the law society talks about corruption and says that the judges are corrupt, I mean, during our time, I remember in 2003 when Kibaki came to power, the law society demanded Chunga to resign. Yes. I read the statement that time because our chairman, our chair lady, Mrs. Omamo, she told us that Chunga is her uncle. She cannot, she cannot read the statement. So we told her no problem. We excused her. So if the law society talks about corruption, and you just need to talk about and agitate about it, corruption will go down. The second fact in the level of corruption is the Chief Justice. If the Chief Justice talks about corruption and the way it is impacting on the justice sector, there will be a huge difference. But if it doesn't talk about, judges will think that it's normal and the Chief Justice has their back. Once that happens, it will be on a runaway. I mean, that's what's happening this time. Our law society doesn't talk about corruption. Our Chief Justice has no idea about that issue. So that is why judges, magistrates, practicing law in Kenya now is very, very difficult. Because I'm sure, I tell guys nowadays, practicing, we have adapted that. Sometimes you can argue a case, you cite the authorities, and the judge has been bribed. But you have developed a certain thick skin that you can argue the case persuasively, and the case will go against you. You don't show any form of despair. You will do your best still. So I think that is the issues we have in the country now.
Thank you so much, Senior Counsel. Colleagues, for those of you who may not know me, I'm seeing cameras around and they're taking pictures. My name is Zaka Lakwanda, P105, and I'm seeing a few of my classmates here so they can confirm that indeed I have been in a law class in this day and age we live in. It's a dangerous one. Thank you, VP, for putting this session together in terms of having to explore and at least understand the lawyer in the judicial ecosystem. And Senior Counsel, we've submitted every, particularly on the limb of corruption. My intervention, maybe perhaps you can share your views on it. It's particularly the counsel in question, the lawyer person, and particularly in the space that the legal profession is finding itself, increasingly finding itself in. It's increasingly and rapidly changing. The numbers that are coming in are incredibly a lot. This year alone, there have been about 2,000 plus new admissions. When you look at the report by the Council for Legal Education Statistics, they indicate that of the lot that leave the Kenya School of Law, only about 36% are absorbed into pupillage positions. Previously, there used to be a situation where there would always be almost one pupil per pupil master, and as such training and induction into the profession was really at a more personalized level. But now when you have 36% of the new recruits or new students joining or being under pupillage, it means that already by the time the rest of the percentage will be joining the profession, they have no training, they have no understanding how the judicial system works, they have not been couched into the culture of engaging the other side of the practice, and that is the judicial arm of the practice. They are basically told to get in and make a living. And that is why these days you hear phrases such as, I don't practice the law, I practice the judge. Because if I understand what it will take, the quality of my pleadings does not matter. I will just simply go the other side and see if I can get that interim order and get that fee paid. So that focuses on the quality of the training and the focus of the council. Is the council, the lawyer that is joining the legal profession today, are properly prepared to understand the ethical foundations that underpin the practice of law and the profession, in this profession? And given the numbers that we are dealing, what are the steps that we need to take in order to be able to at least prepare counsel? Because if the judiciary is corrupt, and yes, it is corrupt, then there must be someone corrupting. Of course, there are clients who already know the judges they want, and sometimes in select cases, they would go themselves and they come tell you, I have dealt with the judge, it's okay. But 90% of the corrupt incidences or bribery incidences will be facilitated by the lawyer. So the role of this lawyer in this process, could it also be hinged on the fact that there is poor ethical training or introduction into the legal profession so that they understand the grounding or the grounding principles that underpin the society. So that would be just what I want to hear your views on.
Well, thank you very much. I mean, you have raised a lot of issues on the lawyer. But you know, one of the theories I've developed about the practice of law is that, you know, unlike in England, the guys who become lawyers are guys from a certain class. I mean, it's like, the guys who become, for example, the guys who become judges in England, they are all barristers, you know. Nobody else becomes judge. And those barristers come from certain families who have a long history of law, you know, generation after generation. Most of them are from Oxford or Cambridge. But if you look at the legal practice in certain societies, it's a very stratified, you know. It's not everybody who wants to become a judge. There's some history. Of course, there are some incidentals here and there. In Kenya, there is no such background, you know. I mean, you can come from a rich family, but majority of us come from a very poor background, you know. So for us, we come with that mindset. When you are in the Faculty of Law, at least during my time in Parkland, we'll just used to talk about a lawyer has bought a car like this, a lawyer has bought a house like this. Right from the start, you are just thinking about money, 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 money. All these stories about lawyers make money are in the law faculties, you know. Yeah. So when you come to practice law, that is our obsession, you know. That I have this theory that, you know, as the current lawyers, you know, have children who become lawyers, or the grandchildren who become lawyers, that hunger for money becomes less. Because when you are the son of a lawyer and you become a lawyer yourself, you will not be as poor as your parents. In fact, you will have certain comfort. I mean, probably when you start pupillage, even your father will give you a car, or me, he giving you a flat. So this thirst for wealth becomes reduced. But I think that's something the Law Society should undertake some empirical studies to see whether lawyers whose fathers or grandfathers are lawyers are less corrupted than lawyers like this. But I agree with you, the training of lawyers is important. But first, I don't subscribe to the theory that Kenya has many lawyers. We don't have lawyers. We don't have enough lawyers. That we are 20,000 does not mean that Kenya has. We are 56 million. I mean, 20,000 is a drop in the ocean. The only problem is all of us are in Nairobi. And I used to tell, when I was chairman of the Law Society, and the branch used to make a lot of noise. I once went to Kisumu, and they made a lot of noise. They said, you know, you guys are spending our money, you don't give us enough. So that time, Kisumu had 86 lawyers. So I told them, you know, there are more lawyers in Jubilee and Ajib House than in Kisumu, which is true. And they don't take like, they get very annoyed. But that's the reality. 70% or 80% of lawyers are in Nairobi. I mean, there are not enough lawyers in northern Kenya, for example, where I come from. No, but Mandera can sustain, in my view, 10 lawyers very comfortable. Same for Wajir, same for Garissa, Marsabit, Marlal. And with the devolution, you know, with the devolution, and these counties have huge budgets. They have 10 million budgets. There's a lot of tenders. The tenders are awarded controversially. So if you are a lawyer, there will be a lot of litigation. I mean, you will go, and nowadays we have courts almost in all the counties. So, I mean, we don't have enough lawyers in this country. We need more lawyers. But we need lawyers to live in Nairobi because, okay, the economy, most of the economy is here, but there are other counties that can sustain, you know, good service. Most of you, when we talk about the quality of lawyers, we talk about pupillage and whether he has done school of law and whether he has been trained properly. I think the quality of lawyer first is defined by the legal education he gets. People think I have something against Moi University. I don't. Not because I taught Nairobi University for some time. But when I was in the JC, there was a lady from, I think she came from Marlal. So when her file circulated, she wanted to become a magistrate. So when her files are circulated, we look at it. So we say that this girl, we don't have a magistrate from Samburu. Of Lenola was with us, Justice Lenola. So we said we need, this girl, we must take her. We want a Samburu girl to be a magistrate in the judiciary. So, okay, we made our mind. So we said, let us take her through, you know, the rituals, but we made up our mind to give her. So we asked her basic questions, you know, law of contract, consideration, you know, the rule in relevance Fletcher, you know, what are negligence. So I asked her, what is consideration? She said, So we thought that is something, we asked her, you know, some basics on the law of this. She couldn't answer a single question. So, I mean, some of us formed the opinion that, I mean, this girl did not go through, you know, either first year or she was not taught these subjects completely. Because there is no way an LLP graduate student cannot know what consideration is. So I think we need to emphasize what is the quality of education in this, you know, students get from the universities, you know. I think that's the starting point. And if, you know, they get fairly average education, I think that will be all. Then you raised the issue of, you know, the ethics of lawyers who corrupt judges. I agree with you. 90% of corruption is through lawyers. I mean, your client doesn't know the judge. I mean, he may ask you out of curiosity whether you know him, but he will not take the initiative. It is us lawyers. You know, we have made our brief. And we have made our brief that we must win the case. Yes. And I tell guys, I like when I appear most against either a bank or, you know, a parastatal or this. Those guys don't bribe. A parastatal has no budget to bribe a judge. Yes. A bank has no budget to bribe a judge. A judge is bribed by the litigant, you know. You know, this either one person company or a family company or a rich man. Those are the guys who bribe judges. Parastatals don't bribe. Because if you're acting, for example, a parastatal, I mean, they don't have budget. There's no way they can make a provision. So corruption is the individual, the walk-in client, the guys who, the guy who was a rich guy, a guy with a business, some factory guys. Those are the guys who bribe. And they always come through their lawyers. Of course, there are some judges also. The good thing is, if both lawyers don't bribe the judge, even a corrupt judge will still give justice because nobody has bribed him. I mean, he will see you the same. It's only when he is bribed that, he tilts the scale in favor of one of the parties. So this thing is in our hands. If we just do our cases, if two of us do our cases, I mean, that's the end of it. Even a corrupt judge will have no option. He will just say that, I'm having a dry spell. Nobody's coming. Yes. But lawyers, we know one another. There are some lawyers nowadays. Sometimes I do a case, then a litigant just drops a lawyer. Then because of that lawyer's reputation, something has happened here. I mean, this guy was not in the case. I mean, this guy, I know him. I mean, he does some of these things. Then he just appears in the case. He is introduced as the lead counsel, and he doesn't even argue the case. Yes. But it's a signal. I mean, you will get the signal very quickly if you are smart, that this one, you are fixed. So I think those are the issues, unless I've skipped anything. Yes.
We can take a few questions from members.
Yes. You can see the hands. But even as members think, senior counsel, most of the time you appear like a lone wolf crying out in the desert about the scourge of corruption and the recommendations, and mostly is on Twitter. And sometimes I follow you silently because sometimes if you dare comment and you don't have facts, you do have tackles. So I tread carefully on your Twitter. But you will see people saying, aren't there frameworks of engagement? Aren't there opportunities? How best can these issues be addressed? Previously, like you say, there was maybe a more bolder LSK. Not to say that, Faith, you guys are not bold. But maybe, the way you mentioned that the LSK could speak and it could be listened to. And yet you're just very few of you at that time. Something happened and yet the impact is not there. But I'm wondering about the framework of engagement. Because here, the challenge is on both sides. There is the law society that has a role to play with its members in terms of how to find or deal with the question of its own members facilitating or promoting or encouraging corruption. Then there's the other side of the judiciary that has also a role to play. So how do we find a middle ground or a framework of properly engaging? Because, to be fair, corruption is not just in the judiciary. If you live in Kenya, it's almost everywhere. Yeah. But today, now for us, where it hurts us most is when you can't get a date without paying something extra. When, those simple services, those simple things, that even clerks are now known to us that, give us something so that we fix you or you get a debt, So what would be some of the best ways to try and have a framework of engagement, to have an honest conversation, maybe even a reporting mechanism where someone suspects, and how to then have a conversation that can actually have an impact on this question, as members think about their questions.
Yes, thank you very much. When I was in the council on the law side, I was in the council for 1 year. Yes, 2 years, I think, before I was elected chairman of the law side. I was impatient. We went to Chunga when Chunga was Chief Justice, and that's the famous time, when he said experts about what, for what, Commonwealth experts were appointed by the Constitutional Review Commission guy, to review the judiciary and what you know, what reforms should be introduced. So Chunga, because, you know, Chunga was the first African Chief Justice appointed, you know, by Moi, after so much agitation by the Law Society, if you forget about Chief Justice Mwenda of the 70s. So the Law Society have always been agitating for black CJ, Kenyan CJ, indigenous black CJ. So the Law Society, like that was our, used to be main demand. We must have, you know, a Kenyan black CJ. We have had many white Chief Justices, we are Asian. So Moi said, okay, you want a black guy? I will give you Chunga. Yes, you know, Chunga that time was, I mean, he didn't go to law school. He was an amazing lawyer, but he did not go to law school. I mean, he did not go to a law faculty. He was just a court clerk. He was a clerk. Then he learned the law. But you know, an amazing lawyer in terms of competence, and he was a very fine DPP when he was appointed. So we went to him. Our chair lady, Omamo, led us, and we complained a lot about corruption. He said, I am on your side, he said. I want us to fight corruption, but give me evidence. Bring the evidence. So, you know, when someone tells you, give me evidence, of course he doesn't want to fight, because we don't collect evidence. I mean, it was fairly obvious that there was a lot of corruption at that time. But in terms of framework, you know, the JSC as it is now is completely dead. I mean, I tell guys, Masharia, he's my classmate, he's a good friend of mine. He has not represented us adequately as he ought to have. I mean, during his tenure, not one judge was taken before a tribunal and removed. Despite all this, there are many complaints. The other day, I said, let me try this complaint. I lodged a complaint myself. The first time I lodged a complaint against a judge, I was representing a client. Then my client, there was a partial decree in the matter, so I made an application under Order 9 so that I can come on record. The lawyer and my client have already wamikosana, so he filed a bill of cost. It was taxed at a fairly large amount. So I told the judge, actually, the lawyer has already taxed this bill. My client has paid some money, and the rest we will see. No, the judge said, no, you can't come on record. Go and bring a bank guarantee. I told her, why is that your business? I mean, are you collecting the lawyer's fees? No, she said, unless you bring a bank guarantee or give an undertaking, you will not come on record. I thought she was joking. So I told her, but the application for a lawyer to come to court is just for notice purposes. That, you know, one lawyer is leaving the case, another one is coming in. The court has no business on the choice of the client. No, she said, there's nothing like that. Unless you pay these lawyers' fees, there's no way you can come on record. So we adjourned the case. The next day, the next mentioned date, she repeated the same. Then eventually she wrote a ruling, said that you can't come on record unless you pay his fees. So, I mean, that's, of course she is acting for the lawyer. I mean, that's a brief. I mean, I mean, there is no other way you can interpret her. It's not her. She is not misunderstanding or misconstruing Order 9, but she is acting for that lawyer. She has an interest. It's 250 million fees. She has. I mean, the judge has an interest in the matter, and she is adamant that my client will not get a lawyer of his choice until that fees is paid. So I put a complaint in the JEC. They didn't reply. After 6 months, I wrote them a letter. I told them, I mean, what happened to my complaint? Then she said, they wrote me a letter. They said, your complaint has been dismissed because I'm challenging the decisional independence of the judge. And you see, that's why I'm talking about the framework. You know, if you want to capture a corrupt judge, the best way to capture is through the judgment. Yes. Because if you say that everything there's an immunity because of judicial independence, decisional independence, you will never capture. You will say that, a judge will say that there are 3 suns in the sky, and then nothing happens to him. You know, something like that. Or he says there are 4 moons at night. Nothing happens to him. But when a judge makes a decision like that and says that, or for example, someone says that, if a judge says, for example, if a judge rules today, for example, and says that Raila is the president of Kenya, is that decisional independence? You can't touch him? Yeah. Isn't that deliberate subversion of the law? In England, there's a time a judge did not write a ruling for 3 months. So when the matter went to the Court of Appeal, the 3 judges, said, how can a decision be delayed for 3 months? And the judge resigned, he wasn't even taken to the JEC or anything. He resigned. In this country, 2 years, 3 years, 4 years, 5 years, until litigants die sometimes, the estate picks up the case. So there is no framework for complaint nowadays. Where do you go if you have a complaint against judges? The JEC does not process complaints. The JEC has a policy not to take any decision against the judges. That is the sad state of Kenya today. Yes. There is no way you can. How can a judge, for example, remain in the judiciary if 5 or 10 or 15 rulings or judgments are pending for 6 months and above? How can you be a judge? Yes. But there is no framework. There is no framework. And that framework, when you have members, we are unrepresented in the JEC. We have only 2 lawyers, and the members of the public represent the executive. They don't represent actually the public. The rest are judges. So unless you have a strong representative in the JEC who can create chaos if his views are not taken seriously, or who has gravitas that the other members will listen to, the JEC will not, we will have no voice and nothing will happen. And I can tell you one thing, unless we have a very reformist Chief Justice, which we don't have now, unless you have a very reformist Chief Justice, there is nothing that will happen in terms of reforms in the judiciary. And the status quo, this will continue. It will deteriorate. Things will get worse and worse. And that is why now, we have to fall back to, institutions like LSK to try to help the matter. So that's why we need a very bold law society. That's why we need a very strong, lawyers, you take these things very, very casual. When you go for elections, you just elect someone. He sleeps on the job for 5 years. You may complain once in a while, but that has an impact on your livelihood. That has an impact on practice. That has an impact on the money you make. Because when the judiciary doesn't function, you can't practice law properly. There will be other alternatives. There will be brokers, there will be third parties. Lawyers will become sort of irrelevant. That's why during this time when we have, need to elect a representative in the JEC or LSK, we need very robust. I'm not, when I became chairman of law society, people used to say, Ahmed, doesn't he has a problem with women or ladies becoming Chief Justice, because I think of my faith. They have not seen a Muslim or Somali chairman of the law society. So there are those stereotypes. But if I ask you now, the lady representative in the JSC or our male representative, when have you seen them, advocating for our issues? When? I have not seen them. I try to look for them once in a while, but they are not there. So you need people who will speak for you. We don't elect our representative because of allowances or because of anything. They represent a very important constituency. And the decision you make now will live with us for 5 years. Nothing will happen. Even nowadays, when lawyers apply for jobs, nobody gives them. When I was in the JC, we used to have a quota, and I'm not bragging. We used to have a quota. If we take 5 judges, there must be 5 lawyers. Whether it's the Supreme Court, whether it's the Court of Appeal, whether it's the High Court, whether it's the magistrate, there was quotas, and everybody used to respect those quotas. The last time, I think, when they were appointing judges into the Court of Appeal, I think they appointed 1 lawyer. Yes. They just Because you don't have a voice. Nobody will say that, you know, my constituency needs representation in this judiciary. So I plead with you, I beg you, you know, when you are electing your chairman of the law society, or your president, they're called president nowadays, or your representative in the JC, don't look into, I mean, look at the broader picture. Look at the broader picture. Who will help us as advocates? Who will help the country so that we have a good judiciary, we have a good legal profession, we have a good society? And I think lawyers always let themselves down in terms of the choices they make during the election period.
Thank you, Senior. We'll now take questions from the law.
Thank you very much. My name is Oyori. I'm from Narok. I'm from a pastoralist environment. I'm very excited to see you. I was tempted to ask you about your cameras. I hope they're fine. I wanted to ask a question. The first question was about the development of our jurisprudence as a country, and about the role of the institutions of the law society, the judiciary, and especially legal education in transforming our jurisprudence. And especially when you are talking about bias, I related to the Koigi Wamwere case, very old case that I think land councils like Gitsogo Manyara, Ben and Chunga, then Orivi and the others were involved. And we see continuously that there is no evolution in our jurisprudence. Our jurisprudence is asleep. And my question is, as a senior counsel and as a person who has a background in academia, where's the disconnect in our legal education? That's we find that our jurisprudence is not growing. We are inheriting jurisprudence either from Asia, Europe, America, and the rest. Then, secondly, I also wish to comment on this issue of the dynamics of pupillage as an avenue of training advocates and as an avenue of preparing advocates to enter our career. Now, ordinarily, when an advocate leaves, when a lawyer leaves the Kenya School of Law, they are by themselves. You know, it's upon yourself to find your own pupillage, your own pupil master, to define the relationship with your pupil master. And at the end of the day, it has, I think, a gigantic impact on the quality of advocate that is prepared to churn out the legal profession. So my question is, what is the role of our institutions, especially the Law Society of Kenya, in ensuring that we have collegiality, especially between young lawyers who are leaving the Kenya School of Law and waiting to be in the profession, so that they are prepared and we welcome them into profession, they are not by themselves. Thank you.
Thank you, Council. I think we also want to make a comment on that second part.
My question is with regard to your last sentiments over the High Court complaint that you made to the Judicial Service Commission. And you created a scenario where it seems like as advocates we do not have any other place to run to make noise, or rather to complain if the Judicial Service Commission is not actually effectively carrying out its mandate. The decision to under Order 909 has been established even by the Supreme Courts. That if an advocate is changing, if a client intends to change an advocate, they have a right. All we need to do is to do that application under Order 909. Having been established because of usage and because of precedent, what can we do as advocates to ensure that judges follow such established precedents, number one. Number two, in the High Court you find before one judge, a judge will actually grant that order, a judge in the same division will deny that order. But I think he placed it properly by indicating that the judge is literally collecting fees for an advocate. What is it that we can do as advocates and as the law society to perhaps ensure that such decisions, such precedents are actually reviewed and actually such judges are punished?
Thank you.
Thank you, Council. We take one more. Then you can answer.
Thank you, Senior Counsel, for such an insightful presentation. Always listening to you, we tend to admire the periods when you led the society, because some of us who are not really privileged to be practicing law at that time, we always wish that we relive that confidence that you and the seniors at that time really had in the leadership of the society. Now, one of the things that you might do, and let's seek your wisdom as well, is that perhaps because of the perceived number of lawyers, there is a bit of over-concentration in particular areas of practice. And this makes the demand for justice very high, and it brings corruption. So my question would be, is there a role that the Law Society should be doing in expanding practice opportunities for lawyers, so that as the number of lawyers increase, circumstances do not really compel lawyers to over-concentrate in the so-called traditional areas of practice? And if we can manage, say, to achieve that through education, through training, through perhaps broader-based CPD programs, perhaps there will be options for lawyers, so that lawyers are not really driven to desperation, where the known areas of practice are the ones that appear like they are the ones that are available to explore, and it becomes a do or die for them, for them to survive to an extent, or even having to approach judicial officers for favorable outcomes. So, what role should the Law Society do to expand these practice opportunities? Thank you.
Right. Thank you so much. I also noticed that one of the aspirants for the Judicial Service Commission is here, and extensive remarks have been made regarding the challenges that we have there. And the President will want to hear your views when we come back. But now I think we start with you, Faith. And I think the last question also appears to be tailor-made for you as well.
Okay. First of all, I recognize council members present. I saw Vincent Kidaiga and also Chrysostom Mahali. Now, let me just kick off in terms of from pupillage joining the Law Society. Now, part of the roles that I took up as Vice President was to see a way that how can we inculcate the young lawyers that were coming in. And we did a mentorship program. And that is part and parcel why we even have this, the INUA WAKILI that was started. The aim is to how can we help embrace you. And part of the topics we did was also branding and preparing yourself. How do you sell yourself, even using the online platform? The young lawyers are stellar in terms of use of technology. I think that's one area you beat all our seniors. I learned quite a bit from the young lawyers in terms of how do we leverage on technology. Also building your website online, building, sharing products that you do. There's a young lawyer who is still at the university, but they have already come up with an AI platform that they want even to partner with Kenya Law Reform for purposes of sharing data, that we're able to have an online repository easy, and also they want to find a way to fragment it easier for advocates. So the aim of the mentorship was how do we bring back that divide between the seniors and the young lawyers. Sometimes finances is a challenge, but more engagements between seniors and the young lawyers. And also to just bring us back after the 2 years of COVID, just that level of seeing each other, spending time. And that's why even as a council, we have seen us supporting a lot of the initiatives that even the TIBA has, and we are always present, available to support, because it's bringing together different advocates. You can share your experiences, you can hear what they're going through, you can learn from them and also see how can I make things better. On Matthew's, my classmate at KSL, in terms of how can LSK embrace new, when we came into office, was to change the trajectory of CPD. CPD has ideally focused only on the basic training that for members to have points. And we moved into specialized CPDs, looking at new robust areas of practice. Now, the reality, like I do corporate and commercial law mostly, competition and telecoms. I can't get to be able to know what's happening in the sector, to be able to learn more. I do conferences for concours de France, which I do now online because COVID helped them have come online. Or else I would have to travel, because I'm also in academia. You're able to travel to attend, to learn what others are doing in the sector, to be able to be competitive, so that you'll be able to bid for work. But that reality also brought that we have many advocates now who are specializing in several areas. And for them to be able to right here at home is to ensure that we change the trajectory of the CPD committee to look into specialized. We have members who have specialized and who are not using that talent, and that's the change and the move to embrace and have more. And the reality of how CPD was also fractured before was to aim for only the experience there for years, and sometimes they don't have the time to sit and be able to train others. And that's why we expanded it, because we are looking at the new emerging areas of practice, and ideally you would find the seniors there. Like data protection, you see Linda Bonio is big on data protection. She doesn't have, unless she's now done a master's on it, but because in practice she has dealt highly on it and be able to develop in that area. You've also developed a niche in your area of practice under corporate law. And by embracing that and changing our trajectory under CPDs, when we're able to ensure members are able to know the new areas, expand. The emerging areas of practice, particularly in our East African region, most investors are coming to Africa, and particularly the East African region, because Kenya is seen more like a hub. You are a developed country, but you're not developed, because they can get all the facilities if they invest in Kenya. Like different, not like Uganda and a few other countries, there's no expropriation of your investment. So investment law is doing very well. Private equity investments, you're seeing the kind of cases that are coming up. Young advocates are still or not on it. We saw recently one of the young advocates challenge even Facebook on some of their laws that on the employees. So the aim of CPD is to move towards that new trajectory, so that we can embrace and help build capacity for members. You saw the CPD committee even embraced climate change as early as August. Despite the critics, climate change was part and parcel of the main theme that was picked up, an anti-money laundering law. Because anti-money laundering is going to become big, particularly for advocates, climate change, and there's so many different areas, looking at FLOCA, the different funds in which people can access. And not just in terms of suing, but also in terms of advisory, and also engaging with the counties in how to develop policies and laws on the same. And that's why CPD picked that particular theme on all the events, from the young lawyers to the women's breakfast to the main theme. So there's opportunities under CPD, and that's the aim that we have been moving towards to make it robust. Let me hand it back to Senior Counsel.
Okay. Okay, thank you very much, Faith. I agree with you. I mean, there are a lot of, areas. Some of us are old school. We still do just litigation in certain specialized areas. But there's a lot of, emerging areas. But the bottom line is, if you don't have a clean judiciary, you're wasting your time. Yes, that's the bottom line. I mean, that's the basics, I mean, whether you are practicing new areas like climate change or anti-money laundering or this niche, it's a waste of time if the because, I mean, the judiciary, I mean, the corrupt judges are like, this wildebeest migration in Masai Mara. I mean, they are the crocodiles in the river. We are the wildebeest that tries to cross. So, many of us get hidden during that migration. So if you don't, if you clean the judiciary, even if you do some small practice of debt collection, I mean, you will still make it big. Yes, small debt collection. If you specialize, there are many things you can do. Medical malpractice. There are certain lawyers that only act for lawyers, whether it is taxation or other kinds of claims against the lawyers. There's a lot of practice on, this KRA and taxation and income. I mean, but bottom line is, will you get a judge that will hear your case, give you judgment in a month's time or 2 months. I remember, for example, when we came into JSC and we appointed, when I came into the JSC, we had only 9 male judges. 9 male judges. So we appointed 9 female judges. They became 18, then we increased more, then we appointed another 15. Lawyers used to have, either 5-2P or appeals used to be disposed of within a year or maximum 6 months. So lawyers get a lot of, you settle your claims quickly. You file an appeal, within 1 year, you have closed the appeal. Whether you have won or not, you will get your fees from the client. Now, the Court of Appeal has the same number. Now they have 29 judges. And judgments, even during Moi's time, I can tell you, during Moi's time, the Court of Appeal never, ever, there was not a single time that a judgment was not delivered on the due date. Never. It never used to, it used to be such a big scandal. Now, we wait, in the Court of Appeal, there are judgments people are waiting for 1 year, 2 years, 3 years, and nothing happens. Nothing happens. The JSC, and I'm glad you said that our representative is here, the JSC has no, it's oblivious. They have no idea that this is happening. Yes. That the judgment of the Court of Appeal, last week I was waiting for one, they sent it electronically. Nothing happened. I didn't, the ruling wasn't sent, they didn't send a letter to say that, it will be sent on another, this is the practice, and this is the second highest court. To be fair to the Supreme Court, nowadays, the Supreme Court is the most efficient court in terms of this. Their system is foolproof. They take you through the motions in terms of preparation. They give you once the pre-trial is over, they give a judgment very quickly. It's a very efficient court, But the High Court is slightly, but the Court of Appeal used to be the best court. But nowadays, unfortunately, it has fallen into hard times. Yes, development of jurisprudence. There's a time I used to call our courts, like South Africa during apartheid, I think had 13 Bantustan, states made for the Bantus sort of. So I used to call the Kenyan courts they were the 14th Bantustan. Because if you look at the judgment of a Kenyan court on constitution, it's just courts, it's a 40-page judgment. 5 is quotations from other jurisdictions. Most judges of this country, if you lock them in a room and tell them to write a prose, a prose of 8 pages, they can't write. You will never see a judgment of a Kenyan court, whether High Court, Court of Appeal, or the Supreme Court, that's a prose without quoting either a book or a judgment of another foreign. You will never see 10 pages. If you see, I'm willing to pay some price.
How much?
But you will never see. So it is reasoning by analogy. For you to reason through this case, you have to quote the decision of another court. In the Supreme Court, American Supreme Court, they don't allow the Supreme Court of America to quote any decision of a foreign court. It's complete prohibition through tradition. They can only refer to their president or something, but they will never refer to a judgment of either the House of Lords or the High Court of Australia or the Supreme Court of South Africa. They don't. Because it's a little bit some arrogance, but they can afford that arrogance because they have developed the law over many years consistently in a very powerful manner. But also I blame the Law Society. The Law Society, the Supreme Court in Kenya now, this is the 12th year, 13th year. We have never, I'm not aware of a faculty of law or even the Law Society that has called for a conference to take an audit of the Supreme Court of Kenya 13 years after. But why has that not happened? It's long overdue. In the 90s, there used to be a lot of conferences, a lot of workshops on the judiciary, on constitutional reforms. The legal sector was a very vibrant sector in the 90s, either through the law society or through the faculties or through, the ICJ. But that's now all water under the bridge. And even the law society during our time, I mean, we used to give, the guys who present the papers some decent money, 50,000 or even 100,000. I think you can afford. And then you tell them, we want you to present a 10-page or 15-page, well-researched with footnotes, to show that there's some effort. Not this, 3-page, 2-page papers nowadays people present in our conferences. And we used to have a book actually. If you look at the 80s and 90s, all our annual AGM conferences, there used to be a book. We used to publish the book, with the papers. You tell the authors, to improve on it. And it used to be, fairly authoritative pronouncement on the law. So I think, I go to the conferences for the Law Society in Mombasa. But the topics are they're very catchy, they look very fancy when you say, for example, there was it GM, genetic, I think there was, the main speaker last time was on genetic modification, something. That's okay, but for the lawyer, the bread and the butter of a lawyer is his legal practice. The area of how, I think the law society needs to have conferences on the judiciary, conferences on commercial law, conferences on, evidence, this kind of things, so that, it becomes very relevant. I've done cases with many lawyers. I think, to be fair to lawyers, if you look at the submissions lawyers make, it's very high quality. Lawyers put a lot of effort. We do a lot of research. Sometimes the judges may not capture that argument in the judgment, but lawyers, the quality of practice in Kenya in terms of, submissions, especially since COVID happened, because nowadays everything has to be in writing, is remarkable in my view. Lawyers really do a fantastic job. And I always tell judges or even lawyers, there's a mismatch in terms of quality. The bar, the quality in the bar is very high compared to the bench. Yes. And that has historically been the case. Yes. The lawyers, some of the submissions when you see, or even the advocacy is very, very high quality. And I think it is something to be proud of. Young lawyers, old lawyers, I've seen this thing, there's a lot of things the law society do. When you become president, you need to appoint people like, Price Waterhouse, people who know how to, they are, okay, we can't afford like McKinsey or Boston Consultants, these big firms, you can't afford. But you can afford something like Price Waterhouse or KPMG to make you a model on how to run the law society in the modern age. They have a lot of ideas, and they will give you models on how to run. And one of the things, when I became chairman of law society, and nobody has done after me, is I raised the subscription fees. I was tired of writing proposals to donors. We used to write to the British embassy, So we said, we don't need donors. What's our budget? And we calculated our budget was like 30, 40, 50 million. And we said, we can raise 100, 200 million. How can we do that? Let us add subscription. We didn't even consult the members, so we said from next year, subscription will be like this. So we tripled our subscription. Of course, there will always be some lawyers who will complain here and there, but our subscription is very low. And if you, at present, I don't think it has changed. At present is that, you have the young lawyers, then you have the middle lawyers, then you have the senior lawyers, then you have the guys over 70. The guys over 70 don't pay subscription to the law society because out of respect. But I think those guys, if you reach 70, you should retire. So the law society, instead of making subscription free for lawyers who are 70, you should make it high so that they can retire. Then you make lawyers of 1 year or 2 years free. Instead of the lawyers of 70, make the lawyers of 1 year or 2 years free. Then the lawyers who are 10 years, to 30 years, you can. I don't think many lawyers will have a problem if you tell them to pay a subscription of 100,000 a year, so that their society's budget becomes 1 billion shillings. When you have 1 billion shillings as a society, you can do so many things. Our annual conference can be free, our CLE can be free, but you need to get ideas on how to run the society at this point in time. Yes, I think the other question was, Rule 9, the lack of complaint, the lack of an effective JSC that processes our complaints. Let me go back to that now that our representative is here. How can a judiciary function if the disciplinary aspect of the JSC does not work? How does it work? If a judge makes all these crazy decisions, if you complain and nothing happens, how, it's not that they work, it's actually that the JSC has given immunity to judges and magistrates. Nobody touches them. You can make all kinds of complaints, but nothing will happen. So the system eventually will collapse. They think they are protecting the judges, but the time will reach that, even the whole credibility of the entire institution, will be judged. And that's why I'm saying the Law Society should come as an alternative. During when in 2003, when CJ Gisheru appointed, the Committee for Radical Surgery, when he appointed, I appointed LSKs also, same time. We appointed a 5-member committee, we gave them a secretariat, we gave them a budget. They went throughout the country, they wrote a 1,000-page document on corruption in the judiciary. Yes. And judges were actually more concerned to see whether they were in the LSK list than in the other one. Yes, yes. So, you see, when you face the obstacles we are facing now with the present Chief Justice and the JSC, the LSK must come with an alternative processes. Yes. The LSK, for example, I don't know whether it still exists, but during our time, the LSK used to, when judges have been recruited, they used to recommend judges, and they used to say that certain people cannot become judges. That is the role of the judiciary. That's the role of the LSK. We must have a say. Even when guys are advertised, the LSK must say that we have gone through this list. Our records show that this person is good to be appointed for judge, and this one should not be appointed for judge. So the LSK must be sometimes the alternative if we have an opaque JC, or if the judiciary is not cooperating, or if we have a JSC that works, we complement that JSC. I think last was the issue of, practice areas. First, we have to consider that our economy is not very sophisticated. There are certain practices we can't do because our economy is very, it's very crude. There are certain things like, the other day I saw, because climate change is it's now the vogue thing. When I was teaching, let me go back a little bit, digress. When I was teaching at the university, I met one of our lecturers. He came back from America, so he was teaching. So I told him, that time everything was environment. Everybody was talking about the environment. So I told him, Prof, what is your area of interest nowadays? He said, nowadays my area of interest is taxation and environment. He said, he's studying the nexus between, the tax law and the environment. So I saw the other day a lawyer saying that now the law firm is providing a lot of legal services on climate change litigation. And I just love the way they are practicing law because, our courts are, we collect debts. Sometimes we act for the mortgagor. Once in a while, there's a JR application here and there. Then there's a few employment cases. I don't think there is, there is the need to develop certain, emerging areas are not available because of our level of economic development. It may be, the bread and butter in certain developed countries. But I think as we go on, we will reach that level.
Thank you so much. Yes, we are coming to you. Senior OO, you have presented yourself to want to go to that hot seat that is under very serious indictment. one of the challenges that I think that the membership or the representative we sent there is no corresponding obligation to report back to the membership in terms of what they're doing there, what have they achieved. And that's essentially what Senior Counsel is alluding to. The fact that we have 2 representatives there, and actually the LSK has no voice and doesn't seem to register in the grand scheme of the existence or operations of the Judicial Service Commission. There have been other comments that Senior Counsel has made, questions on corruptions, questions on the competence levels of the judicial officers, turnaround times on judgments, and questions such as that. Maybe as you come forward to want to represent the Law Society, what are some of the diagnostics that you made and maybe interventions that you have to speak to this question, maybe try and find some solutions?
Thank you for that question. My name is Omwanza Ombati. I would have a few interventions, and then I have 1 or 2 questions for Senior Counsel. So in terms of corruption, it's true that it's now endemic. It's a serious indictment on the judiciary. And I think one of the things that we need to do is probably make an example the way it was done in 2003 or during vetting. I think when you get a corrupt judge or magistrate, we should be so severe that, in terms of how we deal with them, we crucify them on the cross, like maybe the way Christ was crucified, so that everybody is able to see them. And I think the shame of that crucifixion should be what should serve an example to other judges and magistrates. As Senior Counsel has said, it's right now you put in a complaint against a judge or magistrate at the JSC, and the only thing they do is they acknowledge your complaint is noted, and that's it. You don't see anything else after that. So I think there is a failure in that point in terms of how the JSC deals with the disciplinary issues against judges and magistrates. Number 2, in terms of competence, I think also that probably fails in terms of when candidates come forth, for interview, and then they are interviewed by JSC, I think it is us advocates who fail to highlight maybe to the commissioners and the JSC about the candidates who appear to be promoted for judgeship. Because we are the ones who practice with these people every single day. We are the ones who have read their pleadings, we went to school with them, and sometimes, for that short interview, somebody can prepare for 1 month and they come out and perform in a sterling manner. But that should not be the only basis upon which you can judge a person's work for the last 15 to 20 years. I think also as lawyers, it behoves us to turn up whenever there are candidates who have submitted themselves for that process to give our comments. Now, the question I have for Senior Counsel is as follows. Number 1, from our previous representative, there was this sort of I think movement to try and say that a JSC commissioner should not practice, and the ones that represent the Law Society. And I do recall that during your time and the time of Ojienda, JSC commissioners were practicing. At least I recall that you did, and I recall that Ojienda did. So I would ask you to react to that specific issue, because it keeps on cropping up that once we go to the JSC, we start intimidating judges. Number 2 is about this unwritten or this quota between lawyers who are recruited to join the judiciary and the ones from the magistracy and the judiciary. Was this an unwritten rule that was previously in the JSC? And how was it enforceable? How were you able to push that through the commission so that lawyers would also get fairness in terms of representation at the JSC? And the third one, last one, is that this issue of promoting magistrates, especially and judges, it looks like some of it looks like it's almost like a token appreciation to judges by the JSC as they go up, give them jobs for the boys, so that they are also able, they've been doing something for the people at JSC. How are you able to deal with that? Thank you.
Thank you so much. Just one more question. Yeah.
Thank you, Senior Council, Vice President, and members. My name is Vincent Gidega. I'm a council member, upcountry representative. I practice the law from Eldoret. Now, most of my classmates who are 7, 8 years in practice recently applied to be magistrates, and most of them, quite a good number, was considered for the last 2 hirings that have happened. Now, talking to them, because most of them are close to us, one of them told me, because he's an advocate and SRM, that they earn a salary of a take-home of around 90 to 100,000. So my question then would be, after 7 years of practice, do you think that is fair remuneration to our magistrates? Because in that courtroom, they are serving us as advocates, and I'm sure their age mates, even where they are associates or partners, do not earn that money in a month. So do you think that is one of the causes of corruption? And what do you think would be done then to increase such packages? And what is your thought on the role of LSK to ensure that that is enhanced? Secondly, in my, again, 7 or so years of practice, I have seen judges being hired from the bar to the High Court, to the specialized court, courts of record, ELC and ELRC, Court of Appeal, and even the Chief Justice. A good example, Chief Emeritus Mutunga. Why is it then that when it comes to magistrates, I have not seen, I may be wrong, but upcountry, I have not seen a single magistrate, an advocate applying to go to the bench, and he becomes a CM directly. What I've seen is that all of us, when we apply, like if I want to apply, I have to start an SRM, as an SRM. So do you think that is good practice? And is it a precedent that was set probably by yourself and the commission then, or commissions before or after you? Is it anchored in any law? And do you think it's fair for lawyers? I thank you, Senior Counsel.
Thank you. There are several more questions. We just take all of them, then we'll be done.
Thank you, Senior Counsel. I have 2 very, very brief questions. First one is, one thing I really admire you for is that I think 99% of the times I've seen you drive yourself alone, and yet you rub so many shoulders. You wrap up so many people. How do you manage your security? And the second one is, the current administration may not be like the previous one, but you never know, people change. What is your view on when the president refuses to appoint judges? Uhuru did that, I think, sometimes, some of them even 9 months, and were just helpless. Thank you.
Good evening, Catch, 2 questions.
For which I'd like you give us your perspective. One, the issue of corruption, which I think you've been very passionate about. Could it be that the problem is just more than just the judiciary? It is a cancer in society. Because when you look at, they normally say that the fish starts rotting from the head. And even when you look at a stool has 3 legs. When one is broken, then it cannot stand. When you look at the way our core institutions get set up, the way the members of the executive get elected, the way the members of the legislature get elected, many people have indeed confirmed that most of those elections are typically based on sleaze and graft. people bribe political party nominations, tickets, and all that, and they get themselves into those offices. So would you say that it's high time Kenya needed to be deconstructed? Do we need maybe probably a Bolsonaro or a Trump in this country? That is one. Two, on the other issue that also you've been very, very passionate about is that how can we get the professional standards of lawyers in practice to those levels that are needed? Is it a question where CLE is failing? Or is it our university education is failing? What systems and structures can we put in place? Those two. Thank you.
Senior Counsel, Madam VP, colleagues, good evening. I have a question and a comment. On the question, I'll go back to where we started off with the jurisprudential issue. We've seen two decisions recently from the Supreme Court, quite maddening on issues land. And I wonder how we marry that with the fact that 12 years since the authorization of the specialized courts, not a single judge has been promoted to the Court of Appeal, to the Supreme Court. And that expertise that we chose to specialize has not translated upwards. On a comment, I am one of the few who are grateful for the noise you make on Twitter and everywhere you do. You make it seem to those of us who are also frustrated that we're not just yeah.
Good evening, colleagues. Good evening, Senior Counsel Ahmed Nasir and the VP. My name is Caroline Haswa. I have a comment and two questions. The first one, Senior Counsel, is that your reform agenda is like an institution, a one-man army. When nobody could talk about corruption in the judiciary, you did it when you were fairly like a middle lawyer, not even a senior lawyer. Is it possible to mentor people who are willing to sacrifice and keep that talk and keep that torch? I want just to go back when you served in the JSC. If probably your JSC and the leadership of Honorable Mutunga was not so robust, maybe we would not be where we are. How can you help transformative leaders within LSK and within the community to keep the reform agenda alive? That one is number one. Number two, Senior Counsel, we have CPD. How come judges do not have CPD? How come JSC does not have CPD? I'm again looking at the judiciary and looking at the ESCC. You cannot transform without learning new things and unlearning the bad things. What is the biggest challenge for the JSC to commit some kind of time to serious CPD that can give results? Because if you just elect me today to JSC, I'm an advocate. I may not know about corporate governance. I may not know about boardroom politics. Those are things that are important. Our very own member, Catherine Musakali, has come up with a transformative code called the Mwongozo. Is it time for LSK, JSC, judiciary to look at what Mwongozo do we need? Because when I was a young lawyer, we were complaining about these same things that young lawyers are complaining. You were complaining, meaning we are doing something wrongly. We need to change. The last question or comment I have is, I see like arresting or prosecuting people is not deterrent in Kenya. Because I think Kenyans think justice has a price. Do we need to completely transform the way we prosecute corruption and focus more on lifestyle audits and recovery than criminal prosecution? Thank you.
There are two people here. Cohen has threatened my life. There are too many. Okay. Cohen will ask that in the office.
Yes, I think you raised the issue of, when you say that when we elect members, they don't come back to us. There's no corresponding obligation to members to report. I really have no problem with, members we elect to the JEC not reporting to us. What I have a problem with is, and I tell guys, when you are running for an office, especially these important offices like JEC and even the president of the Law Society, you must have an agenda. You must have made up your mind that if I go to this office, these are the issues I want to implement, whether people like it or not. Yes. Some people go to some people go to offices for per diems or allowances or some other things. But when I went to the JEC, I had an agenda. I said from day one that when we are reconstituting the Supreme Court, we will not appoint judges from the lower courts. And we almost achieved, although we didn't achieve 100%. We achieved, I think, a target of 80%. 80% of the judges of the Supreme Court were from outside, either from academia or from private practice or, So that was my agenda, yes. And I pushed it through. I said, I acknowledge many times that the person who was even more powerful in his view on that was the Attorney General of that time. What's his name? Amos. Amos said that, although he was, a player of the politics of the judiciary and government in the 90s, he said he knows all the judges. They were together in Dar es Salaam, and he says these guys cannot sit in the Supreme Court. Because I think he made the view that they were poor students. And I tell people many times, the reason why Willie became Chief Justice was because of Amos Wako. Yes. He's the only guy who marked him, I think, 95%. Yes. Everybody else marked him, including myself, 70-something. But Amos said, I know Willie, I know his capacity, I know the guys who are competing with him, and that is why he marked him like that. So, so if you don't have an agenda, for example, if you don't have an agenda, like, what's his name, my good friend Omonza, I always tell him, if you want me to vote for you, you have to have an affidavit. Yes, that this is what I will do. Yes, this is what I will do. These are my agenda. Then if I agree with you, I will vote for you. But I think we have learned our lessons from, the people who have put this in these critical offices. People have no agenda. You make them a member of JC, they stare at you, like this. Yeah. Yes. So I think we need to have, Omanza talked about, judge appointment, my experience. If you I tell guys, I am most disappointed with, the people we appointed into the judiciary. When I was in the JC, I used to either vote for you because of I know you, or I used to fight you because of what I think about you. And I tell guys, okay, there are fantastic judges we appointed, but some of the judges we appointed, people who are my classmates, people who I used to practice with, people I taught with the university together, people I thought I could, put my life on the line for them and say that this man, I know him, he's a good judge. Those have become the worst. Yes. It is so disappointing, that someone you think you knew, and you put so much faith in him, and you pushed him, then when they come into that position, they completely, come something else. Then the issue of whether commissioners should practice law is, I don't see anything wrong with a commissioner practicing law, as our representative, if you don't know what's happening in the courts, you can't adequately represent us. You must be in my view, you must be a litigation lawyer. to be a good commissioner, because only litigation lawyers know what are the shortcomings in the judiciary, what are the current problems facing the judiciary, what are the remedial measures that we take. During my time, okay, we were very busy with a lot of recruitment, and I appeared in courts. This idea of the judge will be scared. Why should a judge be scared if he's an honest judge? Why? I mean, he's supposed to listen to a case. I mean, during that time, probably he has no disciplinary case, or there is no prospective of promotion. He has not applied for a job. But the JC has certain, process and procedures. You can disqualify yourself if the judge has an issue. All those. There are many judges who thought, Ahmed is the one who stops them becoming judges. And when I leave them, they even perform worse than if I was. And even subsequently, when I left the judiciary, they were still unable to get the jobs they thought I was stopping them. The quota of magistrates, there's no written law, but I think, the issue of magistrates, when I was chairman of Law Society, we told the Chief Justice that the Law Society opposes magistrates becoming judges. Because in England, they don't. In England, if you become a magistrate, you will die a magistrate. So we say, but I found, when I became a member of the JC, I found how wrong my view was. Because they are amazing magistrates. They are very good, especially ladies, if I say. Very good. Yeah, I mean, some of the ladies we met judges, they are some of the best. And during that time, because the appointment system was opaque, a magistrate will not be appointed to become a judge unless there was some serious political consideration. So when we opened the system, the first recruitment, we got some amazing candidates, who are magistrates, ladies who are frustrated, people who with no godfathers, nobody could push them. I mean, the juniors were appointed. So I realized actually that they are very, very good magistrates who can become judges. Yeah. And I think that's the same issue of the promoting of magistrates to become judges. The issue of 7 years practice and 100,000 first, the judiciary actually pays very well compared to other arms of our government. It's one of the best paying institutions in the country. I mean, I think the Supreme Court judges earn from 1 million, 1.5, 1 point, they have all these cars, they have a lot of loans, at cheap rates, they're given. So the judiciary actually pays very well. I mean, but judges want to make money like lawyers. That's the problem. And that is what causes the problem. If you look at, for example, the civil service, or even the Office of the Attorney General or the DPP, I mean, the judiciary pays better than all those institutions. Because they have a lot of, the commission that sets salaries really takes care of the judiciary. And the remuneration and the terms are very good. But, the office of a judge is powerful. I mean, you decide the fate of people, you decide whether cases will be won or lost. And it is that dynamics, that creates a lot of confusion. During my time, actually, I think we had no rule. For example, that if there's an advertisement for chief magistrates, lawyers were allowed to apply. Yes. And why not? If the qualification is, for example, 10 years of practice, if a lawyer qualifies to become a chief magistrate, there is no reason he should not be allowed. It should not be a monopoly of anybody. Yes, there's a question of that. I rub many people the wrong way. Actually, there's a lot of benefits that comes with the position I normally take. I tell you, unless he is a hardcore corrupt judge, most of them avoid taking bribes in my cases because they know I will either fight them or there will be a lot of noise about. So they avoid me, and that's what I like about it. There are majority of them avoid it. Yes, they don't want trouble. They can. There are low-hanging fruits somewhere. Yes. Why mess up with this case? So there's that benefits that come with it. Of course, there are guys who take revenge once in a while, and I'm used to that. But when Justice Tom Belutu refused to listen to me in the commercial court, the first time I raised these issues, I appeared before Justice Gringe in the High Court. Then the lady actually on the other side didn't raise anything. Then he asked her, do you want me to listen to Ahmed or what is? So my learned friend on the other side said, my lord, I have not raised that issue and I have no problem with you listening. Then he said, what Ahmed said is true. I agree to it 100%, but we are not as brave as he is. So that's why we keep quiet. So there are many judges actually who share some of the ideals the Law Society and its members, espouse over time. And then there was the question of why judges, the president refused to appoint a special rule. When nobody writes about the history of these issues, but when the tenor of Uhuru is analyzed in terms of his hatred for judicial independence, it has no parallel in the history of Kenya. Even Moi was not that bad. Yes. Even because, I don't know whether it is his background or not, but Uhuru could not stand an independent judiciary. Yes. He could not stand an independent judiciary, and that is why he was, he destroyed the judiciary big time. He captured the JAC big time in terms of, how many times do you think he has reshuffled the two members he could appoint? Several times. Someone is appointed for 2 years. When they see that, he's not what they want, they remove. I think they removed 2 or 3 times. Then they appointed, then finally, they appointed a certain, type of commissioners that when they wanted to appoint a chief justice of their choice, it was very easy. They had a majority of 6 or 5. If each one was told to give 95 to 99%, they did. And then they were told, the other candidates who you think are strong, give them 40 to 45%. You can't reach that candidate. He will win. And that's how, they appointed members of the judiciary. Okay, I think asking about corruption. Of course, corruption is a cancer in the country. Lawyers are a reflection of the society. This country, but corruption is very superficial in this country. If we have a president who, carries a radical reforms in the country, in the executive, in the civil service, corruption will die very quickly. Even the judiciary, when Kibaki came to power, the first 6 months, corruption was 0. Even the policemen could not take bribe. If you could remember, even civilians, were arrested policemen. Ruto's tenure is very short. We don't have time to judge. But if we judge from, this first 1 year, you don't expect much reforms in terms of fighting corruption. I meet him often. I talk to him about this, and he sees me as too radical. Every time I tell him, you need to do this, he says, Ahmed, why do you want so much chaos? And I tell him, the only way you can jumpstart this country, or even the only way you can make people love you, is if you fight the people who have stolen their money. Yes. Probably he will do 2 years to the election. Let's wait. Yes, I think the issue of, the Supreme Courts and the decisions they make, the jurisprudence, that has been the complaint, especially how they interpret their jurisdiction. One day they can decide a case falls within the jurisdiction. One day they can decide it's not. There is, to digress, the Supreme Court of America in, I think, 18-something, when during the formative stage, every Friday they used to have a rule that if it rains, the 9 judges can sit together and have a glass of wine or whiskey, whichever one they drink. So there's a time it did not rain for long. And the judges were concerned that they were not having the drinks. So one of the judges says, our jurisdiction is very vast. It must be raining somewhere. So they said that when we want to drink, we will drink because it's raining somewhere we are not aware of. So that's the Supreme Court of Kenya. I mean, they can decide. I mean, I have done cases where, you know, it is a pure commercial matter and they will say, no, there are constitutional issues here, and they listen to it. But that's unfortunate. The good lady, in terms of reform agenda and the sacrifice we make, I mean, this is very important, you know, like when Willie was appointed, I mean, I've never met Willie before he was appointed. I met him in a mosque one day, one evening, in one of the prayers, just from far. But, you know, people like Paul Mute and who know him used to have a lot of good things about him. And that's why I was saying that when you are going for an office, for example, you want to become Chief Justice of Kenya. Some people become Chief Justice of Kenya, maybe for the name, maybe for the bucks, you know, the prestige. But they don't have an agenda. They don't have an agenda for that office. So when they assume the office, they become like headless chicken. I mean, they have no idea. And you can only compare, when Willie Mutunga came to office, okay, his background helps him a lot. He was a former chairman of Law Society. He was a professor at the Faculty of Law. He was a former detainee. He was a political activist. I mean, he had a lot of ideas on how to do. And I think there's one day he told us, you know, that this is the, he said we should treasure his tenure as Chief Justice because this is the first time Kenyans or the common people have captured one arm of government. And it is true. I mean, that time, and I've met both, you know, William Ruto and Uhuru after William Mutunga left, and they said if there is a man they have wronged and they did not appreciate how good he was, it was William Mutunga. Yes, because they realized later on, you know, in light of the subsequent experience with his two predecessors, that, I mean, the man had a lot of gravitas, he had a lot of weight, he was very fair, he was... Actually, the first time when we had the first presidential petition, people thought, you know, that, I mean, William Mutunga is an activist, he was political detainee, I mean, he will obviously rule for Raila. And I was among the people who said that, you know, you guys don't know Willie. I mean, Willie is a man who, if his brother comes before his court and is guilty, will jail him and visit him on the weekend to take food for him. Yes. I mean, and it's like that. I mean, for him, the law is the law. But he had an agenda. That's why he made difference. You know, that's why, you know, the courts, I mean, people were happy. I mean, there was, you know, some fresh air. And that's why I said, when you want to become chairman of Law Society or you want to become JSC, I mean, you must have an agenda that you have developed over time. So that when you go there, you say that this is my agenda. I will push through my council or I will push through the JSC. If you don't have an agenda, you will achieve nothing because, I mean, you will be there for the allowances or if it is LSK for the annual conference trips. Yes, for CPD, for judge, actually, judges in Kenya spend almost a month or 2 months attending workshops that doesn't improve the efficiency or their intellect. If you practice in the High Court or the Court of Appeal or the Supreme Court spends more time in Watamu than in Nairobi. Yes, go and check even their budget. They are always in Watamu, the Supreme Court. I don't know, right, a conference. And it's a conference of, you know, they call the 7 of them, plus their clerks and this, maybe a Chief Justice from Uganda. You know, they want to hear their echo. They will never invite their critics, you know, people who have issues with the court, whether it's the academia or the bar. They will never invite. The Supreme Court will go with their staff, spend 2 weeks in Watamu, they come back. They have another case, they go to Watamu or Naivasha. So our courts actually, if we were given CPD like this, when you're a frequent flyer, they will have so much credit because they are always in conferences or workshops or training. But you will never see that efficiency. You will never see those workshops translated into efficiency or something else. I think I have finished. No, on principle, I opposed an ombudsman to look into the judiciary. The judiciary is run by the JEC. The JEC, we are the only country in the world. We are the only country in the world where the president does not appoint the Chief Justice. And it is informed by our history, how Chief Justices were appointed. So when we were formulating this, we made a very powerful JEC. The JEC in our constitution is very powerful. It appoints the Chief Justice, the deputy, all the judges of the Supreme Court, all the clerks, all messengers of the judiciary. Nobody has any say, and I think the courts now have established that the president cannot veto. So what we just need is appointing the right people into the right offices. If you appoint a Chief Justice that has no idea, don't cry later on when you get no idea, because there was no idea in the first place. Kenyans expressed disappointment when they shouldn't, because it was obvious. Some people, when you appoint them into certain offices, you shouldn't expect much, because there was nothing. Yes. There was absolutely nothing. So creating an office of an ombudsman to look into the judges, it will create a problem with the JEC, because JEC disciplines, appoints, and recommends removal of judges. So the JEC does this job. You really don't need an ombudsman. Of course, the JEC has some structural problem. It's dominated by judges. Sometimes the judges, if they become, like a trade union, they become very protective of their members. But when you had someone like Willie was an outsider. He had no relationship with the judges. He used to see his role as a Chief Justice, will be there for 5 years. And if someone is to be disciplined, he will recommend. If you just look at how many judges were removed during his tenure. The DCJ was removed. A tribunal was appointed for another judge of the Supreme Court, Justice Tonoy. Quite a number. So it depends on everything. It's not the office that's important. It's the person in the office. So if you put a zombie in an office, don't expect, anything. Yes. The problem is the person appointing.
So thank you so much, Senior Counsel. I think someone asked me at the beginning of the session whether it would be interesting. I think we have met that expectation. And when coming up with this talk, the clarion call or the thought behind it was this fight for corruption, the fight against the culture of facilitation. I think Senior captured it well, the culture of keeping quiet. We have situations where the Law Society is calling upon you to share views so that we can deal with the question of magistrates who are going for promotion. We keep quiet. When we want to work with the branches on the question of facilitation, you know who is asking for that money. We keep quiet. It's time that lawyers will take on that clarion call that Senior has given us today. As a president or a vice president, the aim is, of course, to be at the forefront. But you need to be at the forefront together with your members. I agree without a doubt, there is a need for judicial transformation. It's not about friendship. It's about the work that is set up for you. And the Law Society under Section 4 has a very clear mandate. I agree with what Senior has also raised about liberalization of corruption. I feel sad when some of my students share with me the challenges they have at the magistrate's court when you need to plan, when you're asking your client for fees, part of the fees belongs to the magistrate, or part of the fees belongs to the judge. Our fees belong to us. Our space is not being taken merely because of corruption being there, but us being quiet to allow corruption to grow and to thrive. It's up to us also to take up this role and fight corruption. And as Senior has said, corruption is done by an individual, mostly through the lawyers. Something that sparked in me is when we were dealing with the Mandamano cases, an idea came from the president about the role of dishonor, particularly to our members at the DPP, and it sparked a reaction, and they responded. Something that we need to think about also, that I agree upon this clarion call by Senior, is we need to start vetting some of these judges and dishonoring them. One judge that has since went through Judicial Service Commission, recommended for his removal. He was part and parcel of one of the judges that was given a demerit, international demerit, of having granted the worst judgments ever. We see us making fun and sharing judgments around, but these are the decisions that are harming our practice. These are the decisions that we need to sanction professionally and also to lay them bare. I agree with Senior, we should push for equal quotas, and that's the notice that we're giving to all our JC representatives that are seeking for that position. Equal quotas for our members, half for the judiciary, half for advocates. But with that said, we also need our representatives that will go there to also ensure that when, be it magistrates, be it judges, be it advocates, when they engage in corruption, we recall them, they leave the judiciary. I think the call for transformation has to start, and has to start with us. So Purity, who sent me a message on the question of facilitation, you're well heard, and I think from even this room, it's very clear that I hope most of us will embrace this clarion call. You don't need to be as brave as Senior and put it on Twitter, but you can be as brave as sending an email to the Law Society. There's a clarion call for us to set up a committee to be able to look into the question of corruption. And that is something that I hope my council will be able to agree with me and take this up. We need to deal with the question of corruption, but corruption also, that clarion call starts with ourselves. We need to be brave enough to also say we will not engage in corruption. And as Senior said, let the judges, let the magistrates have dry spells. It's okay to have dry spells. And also call upon our judicial service representatives that at the end of the day, we also deal with this question that is happening of decisions lying for over 6 months. And some, because we know the judge has not been able to convince the rest of the other judges to incline to his side. And so the only way is to frustrate the decision. So we ask whoever is going to get this position, all our JC reps, please support and work with the Law Society as well, so that we ensure that we fight this thing jointly. I thank you, Senior, for granting us your time, for being able to spell out some of the challenges that you're able to navigate through. On raising of practice, please, I don't think the members will like that. But we have listened, and I think we have embraced some of the clarion calls that have been raised, and the clarion call particularly to fight corruption. I thank all of you that were able to join here physically. The turnout was good, and those who were able to join online. I hope we have been able to take some good takeaways from this meeting, and we hope to have a few more discourses as we build towards how we are going to see the Law Society growing better and greater. Asante.
Thank you. Thank you very much.
Go ahead, your question.
Cohen, you can give us a vote of thanks.
We thank everyone. I think on behalf of the organizers, we thank Senior Council, Mr. Bonasi,
and all the actors, together with the members who are here. I know there are some members who are online, the council members. I have seen Mr. Maura Kabata is online, and others. We thank all the candidates who are here. I know you can interact with the members. I've been where you are. We are still the Mugabe of Nairobi representative. So, but we thank everyone. And I think let's keep it up. And as Senior has said, let us be the voice. Let us not sleep on our rights. And I wanted just to say that the issue of judicial independence is the one that is bringing problems. You quote a case, a judge says I will distinguish the same.
But as we move on, as the society, I think we are headed to somewhere. To all the candidates, including our GSC, Vice President, President, we wish you well. And I think, Madam Face, what you have started, I hope next Friday we'll have another one. Today we had water, next time maybe we'll have other things. Senior Council has said that we can increase the rate. For those, me, I'm still in the middle bar, our chairperson is here. We are not yet there. We are below 10 up. For those who are above 10, will come. But anyway, and for those who are attending also the evening event, we wish you well. And for those who are going far, I will also wish you all safe travels. Let's keep the fire burning for the Law Society, for the betterment of our Law Society. We wish you well. Thank you very much. I think on top of that, may the good Lord be with you.